The
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your podcast on the federal courts of appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. Except this particular podcast won't be about the federal courts of appeals. Indeed, to a large extent, it won't even be about courts or legislatures at all. But, and this is an important point, it will nevertheless be about the law and how the law comes to be. Today is a special Short Circuit where we'll be returning to an occasional series of conversations about cities, housing, and property rights. A few months ago, we spoke with Charles Marone of the organization Strong Towns, as you may remember, about city planning and top-down management versus spontaneous development. And today, we have a similar theme of central planning, spontaneous organization, and the relationship between the two. I'm very pleased to have with us Molly Brady, an assistant professor at Harvard Law School, to discuss an article she is working on, which will be published in the Harvard Law Review and will be available shortly online. It's called Turning Neighbors into Nuisances. Sounds like a Woody Allen movie, by the way. Molly, welcome to Short Circuit.
Thank you so much for having me. I'm so excited to be here.
Well, there is so much to talk about in your draft article, as listeners will know once they're able to read it themselves. I recommend it to anyone interested in current fights about affordable housing and zoning and property rights that has been so much in the news lately. It's also just fascinating legal history. To my eyes, as someone who has written about emergent orders and the creation of law in a non-purposive way, it jumps out to me as a case study and all that. But before we go into any of those tangents, let's just have you give us an overview of what you're writing about and why you like reading 19th century property deeds.
I love 19th century property deeds. That's independent and predates this paper. But the paper itself basically emerged out of reading a bunch of interesting private law cases in which I started to see a form of covenant that I hadn't encountered before. So when I teach first-year property to my students, we talk about covenants, and we typically teach them either in the context of talking about very famous racially restrictive covenants or in talking about big suburban developments and homeowners associations. But as I was reading these 19th century cases, I kept coming across these covenants in which people were promising not to engage in nuisance uses or in noxious uses. And sometimes they would spell out 50, 75 different things that they considered nuisances. And as someone who teaches property and land use, I had never heard of these things. So it seemed like a story worth telling. And then as I kind of unpacked why were people making promises from the 1820s onwards not to engage in tortious land uses, I found a really interesting story about the emergence of the apartment, the ways that property owners tried to use these covenants to prevent the apartment and failed, and how that really contributed to the rise of zoning. So the paper is a story of these nuisance covenants, a discussion of how the apartment ultimately challenged these covenants, and really how that led to the rise of zoning and the outcome that we saw in the famous case of Euclid versus Ambler Realty, in which zoning gets upheld as a legitimate use of the police power, in part by analogy to nuisance prevention. Even though preventing apartments was not something nuisance law did, it became something regulation could do. And so I think that this story helps to fill in a little missing chapter in how we got to this point where zoning was legitimate.
And give us a few examples of these 50 or to 75 nuisances that these deeds would spell out.
Yeah, so this is where I really fell in love with again, I'm an odd person in that I love 19th century property deeds and even earlier ones, but these lists are just so fabulous. You know, they start as banning things like cabinet makers, coopers, turpentine, vitriol, ink makers, all these sorts of things. Then it continues to extend, basically. It just gets added to. So you have people promising not to engage in bone boiling or to build a slaughterhouse. And then eventually it becomes circuses, animal menageries, museums. I'm never really sure why museums ended up on the list, but it just becomes this really specified list of things that people didn't want, which is itself historically interesting as we trace what people thought about different types of uses. And so you get really specified lists that do, in some senses, start to look like boilerplate, things that were just copied from one developer to another. But you also see some interesting little sensitivities where there might be, particular things about bans on oil drilling in places with oil drilling or things like that. So it was a really kind of interesting view into the development of land use and how people were thinking about what they did not want to live near.
Now, tell us a bit about what these developments were. Like when we think of development today, of course, it's some big subdivision. Of course, there's zoning also, but people have to join HOAs a lot of time to live in them, and that have certain covenants that they have to agree to. But like in 1820, what is a developer doing at that point? What kind of scale are we talking about?
It's a small scale. And so prior to about the 1870s, I actually haven't found any covenant that was put on more than about 50 properties. But overwhelmingly, you would sometimes have an owner who might subdivide their lot into three, so a 3-lot development, which is sort of wild to think about now, but they would put covenants on 2 of them and maybe retain the 3rd lot for themselves. And so you had these sorts of covenants going on ranges of property from the really small numbers. And then obviously with the expansion into the suburbs and the development of hundreds of properties by one developer, it expanded along with that to those sort of numbers.
And so this is a kind of a particular question, but I think it might tell us a lot about what was going on. Are most of these properties what we in America today call single family homes, detached homes, or a lot of them row houses? Are they mother-in-law houses? What do they look like?
Yeah, it's a mix. So, in New York, it's already sort of row houses, and the covenants specify things like setbacks, and they specify, again, often these non-nuisance uses. In other places, I'm thinking of things that start to migrate toward upstate New York, for instance. You did have more detached houses in the attempt to preserve detached houses, but you also had covenants going on properties that were what we'd think of today as duplexes or triplexes, really depended on the character of the neighborhood and what the existing type of use was that sort of shaped how these early covenants were drafted. But these nuisance covenants, again, were pretty ubiquitous, regardless of whether it was row houses or single family houses or duplexes or anything else.
And did the nuisances adjust a bit, so I could see like a set of row houses, you would be very sensitive as to what your neighbor is doing, even if it's a rather innocuous business. As long as there's some noise being made, you're going to be sensitive about that versus 1 acre lots are gonna be different. Was there that much calibration, I guess, in these deeds, or did it seem pretty kind of slapdash? We got this from a book, and we're going to put the haberdashery in here and the cobbler in here, but we're not going to think of putting much else.
Yeah, so that's a great question. I think it's funny because I'm going to give the law professor answer of a little bit of both, because I think that there is just copying. I think it's really funny to see in the 1920s, when slaughterhouses are heavily regulated already, people continue to try to contractually ban slaughterhouses, suggesting
just
somebody's
got,
yeah, exactly. Somebody's got their version of the Westlaw form, right, that they're sort of copied over, but then they're tweaking, they're adding things to it. It's rare to subtract things. So that is itself interesting. But, I also have laughed at why were cabinet makers still perceived as especially terrible into the 20th century. It sort of seems insane. But yeah, I think that there is evidence of additive copying. And you think about lawyers probably are risk averse and afraid of being the guy that left the oil refinery out of the covenant and therefore never getting hired again. So I think there's a little bit of that going on.
Now, one thing that struck me in reading it was it's interesting that this emerges, I think, in the 1820s and goes through the 19th century, and we get nuisances added to it. The developments get bigger, of course, as we have more development, more urbanization, and the Industrial Revolution continues. But one thing I don't quite get with the history is, we've had multifamily housing since ancient Rome. The founding generation, colonial America, were very familiar with multifamily housing. A lot of multifamily housing burned, for example, in the Great Fire of London in the 1660s, but nevertheless, it was built back and people were familiar with it. There were developers back then. So what happened in sometime in the 19th century when developers started saying, we don't want these uses, even uses unlike slaughterhouses that you might not really think of as a nuisance. What changed that people started not wanting those uses near them?
Yeah, so I do think that, especially with respect to multifamily housing in particular, there's kind of two things that start to change. One is scale. Just technologically, you can start to build taller buildings as the 19th century goes on. And so I always teach about, the Equitable building in New York that was conventionally thought of as one of the buildings that people mobilized around how tall and giant it was in deciding to zone New York. It cast something like a 7-acre shadow, if I recall correctly. So you have to figure, this has to, I always with my students joke, like, this is an era where the Titanic icebergs are still a major problem. So you got to imagine a 7-acre shadow was a little bit much for people to get used to. So I think that there's scale, and that's kind of increasing in interesting ways in mid to late 19th century, not quite on the scale of, the elevator and really, really tall buildings, but still things like 6 stories maybe. And also, I think there's another thing that is happening in the mid-19th century, which is immigration, right? So immigrants living in tenements, some of the creation of the tenement housing, ideas about the pernicious effects of multifamily housing seem to emerge from both legitimate and illegitimate concerns about tenements. So on the legitimate side, there was not adequate fire prevention. There were not stairwells to get out of buildings that were reasonably accessible. So that, of course, made people nervous. But then there was also class panic and, ethnic panic about immigrants. And I think that was connected to sort of how people perceived who might be living in multifamily housing. But it is interesting, I think, that like these garden square developments, moving beyond sort of banning apartments or multifamily housing specifically, these garden square developments, even in the urban core, they start to want to ban business. And why that is, now we think of one of the amenities of urban living might be your corner bodega or the ability to walk and get a cup of coffee. But whether it's because that was just sort of contractually what people were copying or that was a preference, we know that there were nuisance lawsuits about things like grocery stores in predominantly residential areas. It's maybe a taste shift, something that for some reason in the mid-19th century became less desirable.
And let's talk about the core of the issue, tenements and apartments in a minute. But on that businesses, today with the automobile, although I don't like it, you understand why a subdivision can get away with just saying there's no businesses because most people can just get in their car in 10 minutes. You're at any business you want to be at. But say in 1880, although we think of people having horses and carriages back then, that was still a pretty upper class thing. So for most people, if you need to have anything, you have to walk to a business. So why would people want to live in a development that bans those businesses? And I suppose it's that we're not talking about a modern subdevelopment. We're just talking about a couple blocks. And so even if you ban the grocery store next door to you, you're still going to be able to within 3 blocks get to what you want. And is that maybe how people just were trying to organize themselves?
I also think one of the things that emerges as you read these cases that's sort of fascinating is realizing how old the delivery economy is. That like sort of horse-drawn carriages delivering everybody's groceries and other things seems to have been really prevalent. So that's actually one of the things that also with the rise of multifamily housing, there's a lot of complaints about. There's just going to be more delivery trucks. And so I think that now, especially in the middle of this pandemic, we're all sort of subsisting on deliveries in one way or another. That's a really old notion. And I think it's actually, that's some of what's sustaining, and particularly the bigger places like New York, sustaining urban living, even in places that are predominantly residential.
I hadn't thought about it over the last 6 months, but this delivery grocery that so many of us are doing now is just like the milkman. We haven't really had the milkman in the last 50, 70 years, but he's back.
Exactly right.
And
it's the same sort of thing. Yeah, where maybe now it's rarer that people feel like running out to the grocery store instead they get it delivered. And I think there actually was really a lot of that in the 19th century, particularly among, the upper classes and middle upper class.
Wow. Well, so we've talked a bit about nuisances and how some of these businesses, at common law would be considered a nuisance, like slaughterhouse. It's okay. We know we need slaughterhouses, but they have to be in their own place with plenty of room around them. Then there's kind of in between types of uses. And then there's just people, right? Multifamily buildings. So we have this, you describe this interesting war, in a sense, between the idea of the tenement and the idea of the apartment, which today I think we would think are basically the same thing. Maybe a tenement is a type of apartment, but people did a lot of work to try to point out they were very different at that time. Can you describe what tenement meant, where tenements came from, and then, how the apartment was a reaction to that?
Yeah, so tenements come about early 19th century. It's really contemporaneous, actually, sort of with the nuisance covenant, 1830s-ish, I think is generally when we think of them coming about. But they really arose to house the immigrant population on rapid notice. And so a lot of them were shoddily built. They were associated with bad landlords. They did not have adequate fire protection. They also lacked often indoor plumbing and sanitation. And so this was not somewhere where you would probably want to live when you moved. So tenements are associated, again, with both class panic, fear about immigration, but also with legitimate concerns about the lack of sanitation and with really drastic fires. I mean, if you go through the New York Times in the mid-19th century, you will read about horrible tenement fires and fears, and you could understand why people might be worried about having something with inadequate fire protection next door to a row house or something like that. So in mid-19th century, there's a huge tenement house reform movement. They become subject to regulations. They still, even at common law, were generally not considered nuisances unless there was some sort of severe sanitation problem or the like. So that's another area where regulation had started to kind of gap from nuisance in an interesting way. But oddly enough, the rise of tenement house regulation really sort of created an impetus for the apartment, for things that actually would satisfy these requirements of the tenement house regulation by having sufficient sanitation or by having sufficient air and light. And so it created kind of this regulation that the market filled with the creation of more upper class housing, particularly as it became more expensive to maintain big fancy mansions in cities like New York, whether because the deliveries were expensive or whatever else. There became a real demand for the apartment among the middle and upper classes. And so that really starts around 1870, and they are trying from the get-go to distinguish themselves from the tenements. So they're giving the apartments fancy names like the Dakota, the Stuyvesant, things like that. They're also
and everything was Parisian, right?
Yeah, everything is Parisian, gardens, the Parisian flat. And so they're really trying to set themselves apart from the tenement. But of course, neighbors don't always see it that way when it means more people, more deliveries, and also more middle class residents, because these were, even though they were still very nice apartments, definitely more economically diverse than the Vanderbilt Mansion district, for instance. So there is this initial struggle about, are apartments tenements? Are they subject to the tenement house regulations? Are they within these covenants that sometimes expressly in that list of 50 things banned tenements? Do apartments come within those protections? And the lawyers take pains to try to distinguish them, often in really interesting ways for those of us who love law and language and interpretation, because they go to all these different dictionaries to try to understand what is a tenement, what is an apartment. They do the same thing with other uses. One of my favorites is there's a later dispute I write about a little in the paper as to whether there's a difference between a garage for cars and a stable for horses. And you realize that at the time, most dictionaries just defined garage as stable for cars, which you're imagining the judge trying to get to the bottom of this interpretive problem and can't do so. So there is this really interesting interpretive problem about what sources should we use to decide what's banned within these covenants. And also there is a recognition on the part of judges and others that there is a different class of person living in apartments. And so there is a question about, is this a legitimate reason to permit one and not the other? Would just be about sort of the character of the inhabitant, whether it's a new immigrant or whether it's someone who can afford something a little more upscale.
And often often these deeds, right, would have been written, say, 40, 50 years before the dispute in question. So the idea of an apartment didn't exist when it was written.
Right, exactly. And so that's part of the struggle. It's certainly harder for judges when they are trying to interpret a covenant written much earlier to say, oh, well, they would have said it if they intended to ban it when the thing didn't even exist yet. And so the 1870s is when we start to see the apartment. But a lot of these covenants went in on properties prior to that date.
Now, it seems in most of this litigation that the judges are doing what we are taught in law school happened during this time in a lot of ways, which is they're interpreting this language to allow for alienability and the use of property. And so if you can find a good argument that your building is not a tenement, then it's unlikely the judge is going to enjoin the covenant against you. Is that broadly true? Do we see exceptions to that, or is that pretty much some of what then leads people into saying, well, we need another tool here, which turned out to be zoning?
I think that's right, that it is part of what gives rise to a new tool. It is the case that then, as now, sort of restrictions on the free use of property are viewed somewhat skeptically when they're private, at least. And so the idea that the covenants were restricting the free use of property, they were sort of strictly construed. The nuisance covenant tried to get around that problem a little bit, because by saying, like, we want to ban all noxious uses, the same way that if you were to draft a statute that was a little bit more broadly, noxious is a broader category than a list of 50 enumerated things. And so there was a little flexibility for grabbing new types of uses that weren't included in the 50 through this use of this term noxious or nuisance. But because the apartment is perceived as desirable and good and sort of something that is desirable, at least among the middle and upper classes, it is hard for judges to think of them as noxious, which is itself interesting.
Was there a discussion about, because that I understand that impetus in private law to allow the free use of property. Of course, we at IJ like the free use of property, but we also have a contract here at the same time, and contracts are usually interpreted in ways to try to protect the rights that the parties have bargained for. Was there, is it that contractual rights kind of got left at the side at the expense of property rights, both, again, just in a private law setting? Or is this because a lot of the owners, never signed that covenant in the first place? They bought the property, which the covenant runs with the land, and so there was this, bias against. It might. I might even think of it as a bias left over from Thomas Jefferson against the fee tail and restrictions that we never agreed to but are foisted upon us. Is there some interplay between those two principles?
Yeah, I think that's exactly it. That the covenants, despite being a nightmare for most law students and people who have had to take a bar, they're really fascinating for this reason, which is that they're contracts that we might not even be aware of, that may be just sort of embedded in what we purchase. And so that is definitely something that's going on here. I think sometimes these are sophisticated parties who are buying with knowledge that they can't do X, and then maybe they seem less sympathetic. But I think in a lot of instances, these are buried in the record books, which are much more inaccessible then than they even are now, and they're still pretty inaccessible. And so, suddenly you learn that you're forbidden from having your home business by this agreement made in 1820 when you're a purchaser in 1870. And so that is, I think, what leads to this this feeling of the free use being restricted, not by my own choice, but by something that was kind of buried in a list of 40 restrictions of which I wasn't even aware. Now, we could say those people should be more savvy, and there is a lot of that. But I do think that the other thing is there's very much fear about time duration that you can sense. It doesn't really cash out doctrinally, but initially, some lawyers are worried in this period that if they try to burden the property with covenants that will last for, say, more than 25 years, that they are doing something a little sketchy, which kind of makes sense. That might be like one generation, right? So we would think, okay, after 25 years, people can reassess. But nevertheless, despite their fears, they try drafting these perpetual ones. And that's really the conflict, is that something that's been, in effect for 50, 70, 90 years really does start to restrict what might be the most optimal development at time 2. And so that leads to this conflict.
I like some of the clever arguments that these lawyers made over the years in trying to turn multifamily housing into a nuisance. Especially, and you hear this one today, even the argument that, especially right after the Russian Revolution, that multifamily housing is going to turn people into communists because I guess they don't farm or own property in the way that a good capitalist is supposed to own it. What are some of your favorite arguments that were made along the way? Of course, the most pernicious are the racial and class ones, but there was even a much more than that, right?
Yeah, so I think that the patriotism is super interesting, just as in its historical moment about fears of communism, in the sense that people need a stake in the investment in property encourages people to have patriotic duties. I think the other one that was really interesting that is again sort of dark to be talking about at this moment, but just the palpable difference and the change in tone around the flu in 1918. So the discussion that, well, maybe tenements were associated with more disease, maybe apartments weren't necessarily, but after the flu and sort of the perception that, well, we closed all these businesses, like why didn't we close these places where 300 people were living? That would seem to lead to a lot of disease. I thought it was really wild to be reading that in 2020, and also to be seeing similar arguments in the news about, the end of the city and, multifamily housing as dangerous for that reason, and, sort of flight for that reason. So that was really interesting. And then I think the other thing, which is again a terrible, awful fact of history, was this realization about the ways that notions of race suicide in the early 20th century were playing a role in zoning, or I should say covenant and later zoning rhetoric. So the idea that multifamily housing was discouraging people of means from having children. And thus contributing to society in that way. There's a great in a horrible way, quote from one of these cases where, this judge gives the example of like seeing a woman with a clothed dog. That's the worst portrait of degeneracy, is a woman walking her little dog in a sweater. And I just thought this was written in 1919. And so it's so interesting to see that, then they were thinking of that as sort of like the portrait of like an unfulfilled life, which is just sort of fascinating as a historical matter. So there's just a lot of cool historical color in seeing how people made these arguments that multifamily housing was inherently suspect or bad for society.
But despite all that, despite these racist, classist, I don't know what arguments, they couldn't quite get there, right? And was it just that nuisance? There was this kind of come on factor from people who are increasingly living in cities and being told that multifamily housing is a nuisance. Perhaps judges themselves lived in apartments. So are you talking about me? Or, what was it that just made this project not quite get there?
Yeah, it's a great question. This is the puzzle of the paper, which is I have this sense, and I'll try to describe this more eloquently than it may be in my head, but that tort law is an important site for debate about what we perceive to be harmful. And judges, because they are persuaded by precedent, tend to move more slowly and incrementally in deciding what harms are and in responding to technological change. And one of the interesting things about this story is that contracts sort of come about as a way of expressing a norm of harm. And it's faster contractually to recognize the apartment or declare the apartment harmful. And they're both providing that information through the covenant to judges, saying in their covenants, we don't want multifamily housing, we want single family housing. But also those contracts lay the groundwork, I think, for regulation and for the idea that we can declare something harmful rather than recognizing it as harmful as a judge might in a nuisance case, that we can affirmatively say we don't want apartments, whereas tort law wouldn't really get there as fast, I don't think. Might it have ultimately gotten there? Yes, but I think that it's a slower movement when it comes through the tort law development as opposed to contractual specification or obviously sort of all-in-one regulation.
Right. Let's turn now to that rise, this shift from private law and just recognizing what people were doing, which I mean, I guess to hang on a moment, it seems like in some ways society was saying that these tenements and multifamily building being next door to a single family home was a nuisance, but to some extent they weren't quite ready to say that. Maybe they never wanted to say that. Just as today, I think most people wouldn't outright say that having a duplex next door is a actual nuisance. But nevertheless, planners wanted to get there. And so here's a quote from near the end of your paper that really struck me. If you could lead us out of it. Even if purchasers of covenant-burdened property opt into the rules affecting some subdivision, once those rules are transmitted into ordinances and codes, it becomes more difficult for those who do not wish to be burdened to opt out. That eventually was bought by the Supreme Court. And of course, we live with that as zoning today. Tell us what you meant by that quote, and then tell us how it led into the Euclid case.
Yeah, so this is one of the things that I've always been struck by in teaching land use is how many early zoning ordinances were basically codifications of what was the market covenant. Which is so interesting. And for a long time, scholars, my mentor, Bob Ellickson, among them, have kind of known that homeowners associations or large amounts of covenanted property are kind of operating as this peculiar private government. But it's been really interesting to see the substantive transfer of rules from private into public. And so that quote that you read, I think, gets at kind of the heart of my interest in the dialogue between private and public law here, which is we worry a lot about improper influence by groups, right? You could think of things like campaign finance law, where we're worried about people, unduly controlling the development of things. This is an interesting way, I think, in land use that like the drafting of a really powerful contract that burdens a lot of people ultimately was used as a template for regulation in ways that I don't think we've yet really surfaced or understood, in part because just accessing these deeds is challenging. So part of my goal here is to sort of show, listen, we should be sensitive to migration from private to public. And even though there's a template, we have to be really careful because maybe people can more easily leave a homeowners association if they don't like it. Not everywhere. Some places homeowners associations are quite large and hard to leave. But we know that exiting local governments is more challenging than exiting smaller geographic areas, right? So I think that's some of what I was thinking about there. And then to your point about these not quite being nuisances and still not being nuisances today, I think the interesting thing, which is a really great piece of kind of rhetorical mastery, is this idea of the near nuisance or the nuisance adjacent thing. So we're just going to talk a lot about light and air and traffic and things that we would typically think of as sort of harmful and bad, but never get to the point of declaring them formally a nuisance. You still see that now with discussions of, when people talk about character of the community, that's a factor that was in like ancient nuisance cases. And still at every single, meeting of a zoning commission nowadays or a city council, you hear, oh, we just are worried about neighborhood character. It's just fascinating kind of the way these concepts are really durable. And so this nuisance adjacent idea, I think, is really what kind of underpins Euclid. Euclid has always bothered me for a couple reasons. There's a few, but to list two. First of all, when you teach it to first-year law students, you talk about this analogy to nuisance. So the Euclid case very famously describes apartments or sort of analogizes them to a pig in the parlor rather than the barnyard, which is just a wild quote.
Right, which is how I like to describe my friends who live in apartments.
That's right. But it's bothered me always that the court talks about apartments in Euclid as though they are nuisances, but they are not. And that's part of what this history shows, is they're never really found to be nuisances. So that's always bothered me, the gap between private and then this discussion of apartments as nuisances. And the other thing that's bothered me is Euclid, of course, comes about in what we think of as the Lochner era. And so it's always been kind of a mystery for people who are interested in the Supreme Court's rulings in this time, that how does this ruling of severe regulatory interference with property come about in this period? And I think that sort of this concept of nuisance adjacent helps us understand that, but also the fact that there was so much respect or deference to these widespread contracts about restricting one's property rights, that psychologically that may have played a role in getting people to accept the idea that they couldn't develop their property as they wanted. But also there may kind of have been a freedom of declaring what we don't want that was perceived to be kind of contractual that then underpins the ruling in Euclid that says that that it's fine to declare certain things like apartments harmful and to ban them from different districts within the community. So I think that this story helps us understand how this concept of nuisance adjacency and also how the rise of covenants and the spread of covenants sort of underpins what ends up happening in Euclid later on.
More generally, what critics of like many of us at IJ of zoning today would say about the difference between what's in a covenant and what's in an ordinance, of course, is exactly what you said in that quote I had. And when I think about that, I think about and this might get a little far afield, but many of our listeners are going to be familiar with Ronald Coase and the idea about contracting contracting to alleviate harms between two parties, and the whole Coasean theorem that some of you might have talked about in law school. But Coasean bargaining, as it's called, that assumes that there's a price point where someone could pay to not have something happen to them, whether that's a nuisance or just or something that you want to protect your rights from. And so you can do that with a covenant. You can do that by, say, paying someone across the street not to build a building if you don't want it to. And how zoning is often justified is there is, as Coase recognized, there is this collective action failure where it just doesn't work. And so we need this big zoning regime to protect single family homes or whatever the use is from outside development. Now I would argue that just means that there's a lot of preferences that are aggregated here, and so we're better off not having that zoning because there are a lot of people who lose out when we have zoning, and so it's better to have people negotiate that. But the court disagreed essentially in the constitutional way in Euclid and said that this kind of regulation is okay. Do you think that the court saw this as kind of a collective action problem, or do you think it was more a classist type of thing, as you were saying, as its comments about apartments seem to indicate that this is how everyone's doing it? We're just going to allow what's in private law to become public law, or did they have more sophistication than that?
Yeah, I always teach Euclid as a classic mixed motives case. And I often have my students read closely the paragraph where they talk about the opinions of experts, and I'm quoting there. And they sort of go through things where you're sort of saying, yeah, that seems like something you would want to legitimately prevent ex ante. And then they talk about the apartment and the sort of things that are much more suspect. And so I think of zoning as sort of mixed motives, really classically, of both being about class and about, legitimate things like wanting to prevent the factory from going in the place where it would be undesirable. Now, of course, Coasean bargaining tells us maybe we would get to a place where the factory would not want to locate there, whether that's because, there's some price or some bargain that could be struck, or because, as we know, there would be sort of socially bad effects for the factory that decides to, locate and really hurt a bunch of people. But it's interesting that I do think that there is a sense that zoning solves a collective action problem, even in the court's mind. The proponents of zoning, the city planners and lawyers who make the arguments in its favor, simultaneously portray private law as both too flexible and too inflexible. It's really hard to pin down what exactly they're trying to get at. They're saying, well, it's not good enough at preventing things like apartments, or it's unpredictable. Sometimes judges will suspend a covenant because of changed circumstances or something that's just far too unpredictable. But then they'll also say things like, oh, and these covenants have been in effect for a long time and are describing uses that are no longer present. So it'd be better to get this into public law where it'd be both more frequently updated and more durable. Well, what we know, and again, Bob Ellickson has written a great paper on this called The Zoning Straitjacket, is that zoning never evolved. It's not like things that became single family ever became anything else. There was no evolution. And so now with that history in mind, it's useful to remember, I think a la Coase, that every solution has costs. It's not just the transactions costs of private bargaining, but it's also the costs of the inflexibility and with the massive economic effects that we now know zoning has had.
Right. Well, let's take that in our time left up to today. And right today we have lots of critique of zoning. We've had some funny discussion in the political discourse in the last month or two about zoning by the president. We don't need to get into that, but overall, there's a lot more realization that zoning pushes up the cost of housing, whether it's single family, multifamily, what have you. It doesn't allow for organic change within a community that you need over time. What can your findings tell us about how people trying to reform the system can go about it, whether that's whether tactically or how their understanding of the relationship between private law and public law could influence policymakers who are trying to fix things today?
Yeah, so this is sort of my most adventurous claim and the one I'm probably least persuaded of myself, but I'm really intrigued by the ways that private law lets us deliberate about harms that may become subject to future regulation. I've actually written another paper in which I also engage this theme on, of all things, light projections onto property and whether those are trespasses or nuisances. And I think there's an important dialogue that takes place in public law or private law that can inform how we think about regulating. But I think it's something we have to pay attention to in the land use context, because a lot of the things that were declared harmful through these covenants, ultimately those same arguments were marshaled in support of regulation in ways that judges were primed to hear because of having decided years of these private law cases. And so I think sometimes these widespread contracts that run for a long time can act as kind of trial balloons for regulation in ways that we might not have expected. And where I see this now, and this is again a little adventurous, but things like the solar panel or like home sharing, those are being written into covenants, and judges are hearing arguments that home sharing falls within, again, the old nuisance covenant, that it falls within an noxious use, and so this is a site
for vacation rental versus long-term rental.
Right. Yeah. This is a site for thinking about what are the things we view as harms that later may become subject of tomorrow's regulation. And so I think to the extent we're trying to anticipate the directions that judges are likely to take when they're evaluating regulation that affects property, it's useful to at least look at the arguments made and evaluate what we think of them, whether we think it's sort of manipulated evidence or whether we think it's really actually valid legal argument. I think it's a good site for thinking about how we are deliberating about harm in the private law context, which doesn't get as much attention as public law, in part because it's just harder to do the work of evaluating deeds and paying attention to HOA regulations. It's much easier to use kind of the free information about public law to track what's happening. But I would like to redirect us toward private a little bit.
Well, as I often try to remind people, law often is, as they say, the product of human action, but not necessarily of human design. When it's in a private context, and of course, when a legislature or a city council legislates it, it's very much of human design. But then we have unanticipated human action, unfortunately, following from that. Well, I'd like to thank very much Professor Brady for coming on this podcast to talk about this fascinating paper. Again, it will be available shortly online on her webpage and also on SSRN, the Social Science Resource Network. For all of those interested in freeing up property rights to protect to alleviate affordable housing and allow us to create more housing for people and to better exercise our property rights and better get along with our neighbors, I encourage the article to all of you. So thank you again very much for coming on, Molly. Anything else to leave us with?
No, thank you so much for having me. This was really fun.
You bet. And next time, we'll be talking again about the federal courts of appeals. And in the meantime, I will again remind all of you to get engaged.